Welcome! Today, we're diving into the world of administrative law. You might have heard the term before, but what does it really mean? Administrative law is a branch of public law that governs the activities of administrative agencies of government. These agencies are responsible for carrying out laws passed by legislatures, and they play a crucial role in our daily lives. From regulating food safety to overseeing environmental protection, administrative law ensures that government agencies act within their authority and follow fair procedures. In this video, we'll break down the basics, explore why administrative law matters, and look at how it impacts individuals and businesses alike. Let's start with a clear definition. Administrative law is the body of law that regulates the operation and procedures of government agencies. It sets out the rules and guidelines these agencies must follow when making decisions, issuing regulations, or enforcing laws. Unlike criminal or civil law, administrative law focuses specifically on the actions of government bodies. Its main goal is to ensure that agencies act lawfully, fairly, and transparently. This area of law helps balance the power of agencies with the rights of individuals, providing mechanisms for oversight and accountability. Why do we need administrative law? As governments grow and take on more responsibilities, they create specialized agencies to handle complex issues like health, safety, and the environment. Administrative law exists to ensure these agencies don't overstep their boundaries or misuse their power. It provides a framework for how agencies create rules, enforce laws, and resolve disputes. Without administrative law, there would be little oversight of agency actions, which could lead to unfair or arbitrary decisions. This legal framework protects the public and upholds the rule of law. Administrative law serves several important functions. First, it governs how agencies make rules and regulations. Second, it sets out procedures for enforcing those rules. Third, it provides ways for people to challenge agency decisions if they believe their rights have been violated. These functions help maintain a balance between efficient government action and individual rights. By setting clear procedures, administrative law ensures that agencies act consistently and fairly, and that there are remedies available when things go wrong. To better understand administrative law, let's look at some examples of administrative agencies. In the United States, agencies like the Environmental Protection Agency, EPA, Food and Drug Administration, FDA, and Securities and Exchange Commission, SEC, are all governed by administrative law. These agencies have the authority to create regulations, enforce laws, and make decisions that affect millions of people. Each agency operates within a specific area, such as environmental protection, public health, or financial markets, and must follow administrative law procedures in its actions. One of the main roles of administrative agencies is rulemaking. This is the process by which agencies create new regulations to implement laws passed by legislatures. The rulemaking process usually involves drafting a proposed rule, seeking public input, and then finalizing the rule. Administrative law sets out the steps agencies must follow to ensure transparency and public participation. This process helps make sure that new regulations are well considered and reflect the needs and concerns of the public. Administrative agencies don't just make rules, they also enforce them. Enforcement powers allow agencies to investigate violations, issue fines, and take corrective action when necessary. For example, the EPA can fine companies that pollute the air or water, while the FDA can recall unsafe products. Administrative law outlines the procedures agencies must follow when enforcing regulations, ensuring that enforcement is fair and consistent. This helps protect the public and maintain trust in government agencies. Another key function of administrative agencies is adjudication. This means resolving disputes or making decisions in specific cases, much like a court. For example, if a business disagrees with a regulatory fine, it can challenge the decision through an agency hearing. Administrative law provides the rules for these hearings, ensuring that both sides have a chance to present their case and that decisions are made fairly. Adjudication helps resolve conflicts efficiently and gives people a way to challenge agency actions. Administrative law comes from several sources. The main sources include statutes passed by legislatures, regulations created by agencies, and court decisions interpreting those laws. Additionally, agencies often have their own rules and procedures, known as administrative codes. Together, these sources create a comprehensive legal framework that guides agency actions and protects individual rights. Understanding where administrative law comes from helps explain why it's so important in our legal system. Most administrative agencies are created by statutes, also known as enabling acts. These laws define the agency's powers, responsibilities, and limits. For example, Congress might pass a law creating the EPA and outlining its authority to regulate pollution. The Enabling Act serves as the foundation for everything the agency does. Administrative law ensures that agencies stay within the boundaries set by their enabling acts and don't exceed their legal authority. Once an agency is created, it can issue regulations and rules to carry out its mission. These rules have the force of law and affect individuals, businesses, and other organizations. Administrative law requires agencies to follow specific procedures when making rules, such as providing notice and allowing public comment. This process ensures that regulations are developed openly and that affected parties have a chance to participate. Administrative law also provides for judicial review, which means courts can review agency actions to ensure they comply with the law. If someone believes an agency has acted unfairly or exceeded its authority, they can challenge the decision in court. Judicial review acts as a check on agency power, making sure that agencies don't violate individual rights or ignore legal requirements. This process is essential for maintaining the rule of law and protecting the public. In the United States, the Administrative Procedures Act, or APA, is a key law that sets out the basic rules for federal agencies. The APA establishes procedures for rulemaking, adjudication, and judicial review. It requires agencies to act transparently, provide notice of proposed rules, and allow for public input. The APA is designed to ensure fairness and accountability in agency actions, and it serves as a model for administrative law in many states. Administrative law isn't just a federal matter. Each state has its own administrative agencies and laws that govern their actions. State administrative law often mirrors federal law but is tailored to address local issues and needs. State agencies regulate everything from professional licensing to environmental protection at the state level. Understanding both federal and state administrative law is important for anyone dealing with government agencies. Administrative law judges, or ALJs, play a vital role in the adjudication process. These judges preside over agency hearings and make decisions in disputes between agencies and individuals or businesses. ALJs are independent from the agencies they serve, ensuring impartiality and fairness. Their decisions can often be appealed to higher courts, providing another layer of oversight and accountability. Due process is a fundamental principle in administrative law. It means that agencies must follow fair procedures when making decisions that affect people's rights or interests. This includes giving notice of proposed actions, providing an opportunity to be heard, and making decisions based on evidence. Due process helps ensure that agency actions are not arbitrary and that individuals have a chance to defend their rights. Notice and comment rulemaking is a key feature of administrative law. Before finalizing new regulations, agencies must publish a notice of the proposed rule and invite public comments. This process allows individuals, businesses, and organizations to provide feedback and suggest changes. Agencies must consider these comments before issuing the final rule. Notice and comment rulemaking promotes transparency and helps ensure that regulations are well-informed and balanced. Ex parte communications refer to private discussions between agency officials and interested parties during rulemaking or adjudication. Administrative law restricts these communications to ensure fairness and prevent undue influence. Agencies must disclose any ex parte contacts and give all parties a chance to respond. These rules help maintain the integrity of the administrative process and build public trust in agency decisions. Administrative hearings are formal proceedings where agencies resolve disputes or enforce regulations. These hearings are similar to court trials, but are usually less formal and more flexible. Parties can present evidence, call witnesses, and make arguments. Administrative law sets out the procedures for these hearings, ensuring that everyone gets a fair chance to be heard. The outcome of a hearing can often be appealed to a higher authority or court. If a party disagrees with an agency's decision, they often have the right to appeal. Appeals can be made within the agency or to an external court. Administrative law outlines the procedures for appeals, including deadlines and requirements for filing. This process provides a way to correct errors and ensure that agency decisions are lawful and reasonable. Appeals and review are essential for accountability and fairness in administrative law. When an agency acts unlawfully or unfairly, administrative law provides remedies. These can include reversing a decision, ordering a new hearing, or awarding damages. Courts can also issue injunctions to stop agencies from taking certain actions. Remedies help ensure that agencies are held accountable and that individuals have a way to protect their rights when things go wrong. Administrative law places important limits on agency power. Agencies must act within the authority granted by their enabling statutes and follow established procedures. They cannot make arbitrary or capricious decisions, and their actions must be based on evidence and reason. These limits protect individual rights and prevent abuse of power by government agencies. Legislatures often delegate authority to administrative agencies to carry out complex tasks. This delegation allows agencies to use their expertise to develop detailed regulations and enforce laws. However, administrative law requires that the delegation be clear and limited. Agencies must operate within the scope of their delegated authority and cannot make decisions that go beyond what the legislature intended. Chevron deference is a legal principle that comes from a famous Supreme Court case. It means that courts will defer to an agency's interpretation of a law if the law is unclear and the agency's interpretation is reasonable. This principle recognizes that agencies have expertise in their areas and are often better equipped to interpret complex statutes. However, Chevron deference is not unlimited. Courts will step in if an agency's interpretation is unreasonable or goes against the law. When reviewing agency actions, courts often use the arbitrary and capricious standard. This means that an agency's decision must be based on reason and evidence, not on whim or personal preference. If a court finds that an agency acted arbitrarily or without a rational basis, it can overturn the decision. This standard helps ensure that agencies act fairly and make decisions that are justified by the facts. Not everyone can challenge an agency's decision in court. To have standing, a person must show that they are directly affected by the agency's action. This requirement ensures that courts only hear cases where there is a real dispute and someone's rights or interests are at stake. Standing is an important concept in administrative law because it limits who can bring lawsuits and helps courts focus on genuine controversies. Before going to court, individuals usually must exhaust all available administrative remedies. This means they must first try to resolve their dispute within the agency, such as by appealing a decision or requesting a hearing. Only after these options are used up can they take the case to court. This rule helps agencies correct their own mistakes and reduces the burden on the courts. Agencies often have discretion in how they interpret and apply laws. This means they can make choices about how to enforce regulations or resolve disputes. Administrative law sets limits on this discretion to prevent abuse and ensure consistency. Agencies must explain their decisions and follow established procedures, but they also need flexibility to adapt to changing circumstances and new challenges. Transparency and accountability are core values in administrative law. Agencies must provide information about their actions, decisions, and procedures. This includes publishing rules, holding public hearings, and responding to requests for information. Transparency helps the public understand what agencies are doing and why, while accountability ensures that agencies are answerable for their actions. The Freedom of Information Act, or FOIA, is a federal law that gives the public the right to access government records. Under FOIA, agencies must provide documents and information upon request, with some exceptions for sensitive or confidential material. FOIA promotes transparency and helps people hold agencies accountable for their actions. Many states have similar laws for state agencies. Sunshine laws require government agencies to conduct their business in public. This means holding open meetings, publishing agendas, and allowing public attendance. Sunshine laws are designed to prevent secret decision-making and promote openness in government. By making agency actions visible, these laws help build trust and ensure that agencies are acting in the public interest. Administrative law plays a key role in protecting individual rights. It ensures that agencies respect due process, provide fair hearings, and do not discriminate. When agencies make decisions that affect people's lives, such as granting licenses or imposing fines, administrative law provides safeguards to ensure those decisions are fair and lawful. This protection is essential for maintaining public confidence in government. Businesses are often affected by administrative law, especially those in regulated industries like healthcare, finance, and energy. Agencies set standards for safety, quality, and fair competition. Administrative law ensures that businesses have clear rules to follow and a way to challenge agency decisions if they believe they are unfair. This legal framework helps create a stable environment for business operations. The public interacts with administrative law in many ways, from applying for permits to receiving government benefits. Administrative law ensures that these processes are fair, transparent, and accessible. It also provides ways for people to challenge agency decisions and seek remedies when their rights are affected. By setting standards for agency conduct, administrative law helps protect the interests of all citizens. Administrative law is not limited to one country. Many international organizations, such as the United Nations and the World Health Organization, have their own administrative rules and procedures. These rules help manage complex global issues and ensure that international agencies act fairly and transparently. Understanding international administrative law is important in our increasingly interconnected world. Administrative law faces many challenges, such as keeping up with technological change, balancing efficiency with fairness, and addressing public concerns about agency power. Agencies must adapt their procedures to new realities, like digital communication and data privacy. At the same time, they must ensure that their actions remain transparent, accountable, and consistent with the law. These challenges make administrative law a dynamic and evolving field. Efforts to reform and modernize administrative law are ongoing. Lawmakers and agencies regularly review procedures to improve efficiency, increase transparency, and better protect individual rights. Reforms may include updating rules for digital communication, streamlining hearings, or enhancing public participation. These changes help administrative law stay relevant and effective in a changing world. Technology is transforming administrative law in many ways. Agencies use digital tools to manage records, communicate with the public, and conduct hearings online. Technology can make agency processes faster and more accessible, but it also raises new questions about privacy, security, and fairness. Administrative law must evolve to address these challenges and ensure that technology is used responsibly. Public participation is a cornerstone of administrative law. Agencies often seek input from individuals, businesses, and organizations before making major decisions. This participation can take many forms, such as public hearings, written comments, or advisory committees. By involving the public, agencies can make better decisions and build trust in the regulatory process. Ethical conduct is essential in administrative law. Agency officials must avoid conflicts of interest, act impartially, and serve the public interest. Many agencies have codes of ethics and require training for their employees. Ethics rules help ensure that agency actions are guided by integrity and that public trust is maintained. You might not realize it, but administrative law affects your daily life in many ways. From the safety of the food you eat to the quality of the air you breathe, administrative agencies are working behind the scenes to protect your health, safety, and rights. Understanding administrative law helps you know your rights and how to interact with government agencies when needed. Administrative law offers a wide range of career opportunities. Lawyers, judges, policy analysts, and agency officials all play important roles in this field. Careers in administrative law can be found in government agencies, private law firms, nonprofit organizations, and international bodies. Working in administrative law means helping shape policies, resolve disputes, and ensure that government actions are fair and lawful. If you're interested in law, public policy, or government, studying administrative law can be a great choice. Courses in administrative law cover topics like rulemaking, enforcement, judicial review, and agency procedures. Understanding this field gives you valuable insights into how government works and how laws are implemented in practice. To sum up, administrative law is a vital part of our legal system. It governs the actions of government agencies, protects individual rights, and ensures that agencies act fairly and transparently. Whether you're a business owner, a public official, or an ordinary citizen, administrative law affects you in many ways. By understanding the basics, you can better navigate the complex world of government regulation and protect your interests. As society evolves, so does administrative law. New challenges and opportunities will continue to shape this field, from advances in technology to changes in public expectations. Staying informed about administrative law helps you understand your rights, participate in government processes, and contribute to a fair and effective legal system. Thanks for joining us on this journey through administrative law.